Folks, let's go ahead and get started. I have a big job today. I get to introduce our Chief Risk Officer, so I'm really stressed out. But you all know Becky Cady. I think many of you would get phone calls from our legal office, right? They'd like to help us with cases, and I think when they call us and inquire about how we're doing, it's actually amicable and friendly, and we have a great relationship with our risk group, and I think that really sets us apart from many places. Becky Cady is our Chief Risk Officer. She's been here approximately clinically, she's a nurse, and then she's gone onto the risk side and really become a national leader working with quality and safety and partnering on how we drive outcomes. She will talk today about real cases that have happened here at Children's National. All of them have happened here, and what we have all felt from our executive safety team that we've got to bring this attention to our front line. So Becky is going to talk about these cases. We'll have a great discussion and hopefully ultimately drive ourselves to better outcomes. So Becky, thank you, and go from there. You'll tell us about the candy.
Yeah, the candies, we'll pull that out later. So we will be doing some polling slides. If you have your device on you, please do get ready, because I think this is an important part of the interactive process. I don't want to be up here like Charlie Brown's teacher, blah, 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 talking at you, right? So, and now's your chance. Like, you have a lawyer with over 20 years of experience dealing with these questions in front of you for an hour. So if you don't have any questions about informed consent that you want to ask me, I would be really kind of surprised and sad. So use this opportunity to ask questions. I really do believe that the most efficient use and the best use of our time together is where you ask questions, because you can learn as much from the questions that each other have as you can from me standing up here talking at you. But there are a couple of, important things that we want to highlight, not only kind of arising out of our recent Department of Health survey, but as Rahul indicated, a number of situations have arisen in the last 6 months or so that raise concerns about informed consent that we just want to make sure everybody kind of has a shared mental model about. So with that, I will go ahead and get started. The objectives for this session are on the poster. I didn't put them in the slides, but we want to make sure that everybody understands the importance of informed consent, what our expectations are here at Children's National about how that process plays out, and then things you can do to improve your own practice in that regard. So talking as a lawyer for a moment, there are very specific requirements for a patient to bring a legal claim for a lack of informed consent, and you basically see those here. There's a material risk that doesn't get disclosed to them, and that risk happens, it materializes, and it causes injury, and they wouldn't have consented to the procedure if the risk had been disclosed. Now, I'm sure it's obvious to everybody that that last bit is very subjective, right? I mean, it's after the fact. It's very easy for a parent or a patient to say, well, if I had known that this was going to happen, I would never have agreed to this, right? Because, of course, now the thing has happened, and it's always something bad. So even though they don't necessarily sit down and say to themselves, well, I'm going to lie under oath about this, perceptions change based on outcomes, and oftentimes our families are under a great deal of stress when we're having informed consent discussions with them, and so they may not remember the conversation the way that you do, and that's an important thing to keep in mind. The parent's perspective may be different from yours in terms of the information that they're hearing and what they're retaining, okay? So what do we talk about when we're talking about material risk? Well, and this is the legal definition. What risk would a reasonable person consider significant in deciding whether they were going to consent to the procedure or not? If a case goes to trial on an informed consent claim, the jury gets to decide if the risks were sufficiently material enough to create a duty to disclose them. Why is this dangerous? Because really the patient does not need any expert testimony to get this issue to a jury. In most of the things that we fight about in a medical malpractice case, we have to have an expert tell the jury, hey, this is what the standard of care requires, right? And this is what was done, and so here's the gap. This is where the defendant breached the standard of care, this is how it caused harm to the patient, and so forth. But when it comes to informed consent, they don't really need an expert to get that to the jury. And it's dangerous because then the jury people, who are lay people, most of them, although in D.C. the juries are getting better. It used to be that you didn't want to ever try a malpractice case here, but that's changing. And people take cases to trial. I mean, MedStar has taken birth injury cases to trial and won them. So the juries here are much better, but what you end up with at this point is that each individual juror kind of, by human nature, looks at it from their own point of view. Like, would I have consented to this? Would I have thought this was important? And so, given that you can't really get inside the mind of a juror and figure out or predict what they're going to say, it becomes sort of unpredictable, which in the defense world, we don't like that. We want to go into a trial kind of having a feel of how well this case is going to play out. So this is how it would play out if an informed consent case ever got in front of a jury. So, all right, so now we're going to start with a couple of questions. And these questions are kind of to lead us into, well, all right, so we have to give informed consent. What are the really important elements we need to make sure we're covering in informed consent? So let's go ahead and read this situation. And I would say this is the only situation that I'm talking about that didn't actually happen here. But it did happen in the district, and there is actually a court case on this. So an adult patient meets with her doctor. For whatever reason, this patient needs to get a tonsillectomy, and that's going to take place at a teaching hospital, not too far from here. The doctor gets that patient's informed consent. The procedure is done. She develops complications, and she sues. And as part of her claim, she not only includes a claim for lack of informed consent and malpractice, but she includes a claim for a consumer fraud under a consumer fraud statute because a first-year resident performed her surgery, and she claimed that the surgeon did not inform her of the fact that a trainee was going to be materially involved in her case. So, I'm going to vote. Does this patient have a legitimate claim for consumer fraud? So, A is for yes, B for no, and C for not sure. Oh, sure. There we go. And I know they've had some issues with the Wi-Fi, so if it doesn't work, we'll have to go to the old-fashioned way and raise hand. All right, everybody good with that? Yes, I'll leave it for a second. All right, everybody good? All right, I'm going to go back to the question. All right, looks like some people are getting through. We got some numbers popping up. Can anybody read that? Oh, gosh. Wow. Okay, so is everybody who wanted to vote voted? All right, so it looks like we're evenly split between A and B. Well, the court in this case said, A, yes, the patient does have a legitimate claim for consumer fraud under the D.C. statute. Okay? Yes, this was my reaction. I see heads going like, people's eyes getting wide. This was my reaction when I read the case as well. This has become a big topic amongst healthcare law sectors and in terms of governmental looks at fraudulent billing practices. So there's been a lot in the literature lately about, and in the media, about double booking, right? There's a surgeon in Boston, I think, who's in a big pot of trouble because, you know, he's basically allegedly performed way more surgeries than any human being could actually perform during the course of a day. And of course, so the government comes in and says, how is this possible? And they look and they see, well, he wasn't actually really, you know, he was going back between rooms and so forth like that. So there's a big push by federal payers and others to look at this issue. And obviously the way that one double books surgeries is that, you know, people, either assistants or trainees, are performing the bulk of those cases. So it's something that we just need to have on our radar and make sure that we're being careful when we have these discussions. Now, and you would think, okay, there's an educated person going to a teaching hospital. How could you not know that trainees will be involved in your care, right? But the point of this case was that it wasn't made clear to her, and she alleges, that a first-year resident, somebody who's obviously at the lower end of experience and I think in most cases probably doesn't have a medical license, right, was materially involved and performed, at least in her allegations, the bulk of this case. So every case is dependent on the facts, right? But this is a case I just wanted to highlight as it's local, and it's a teaching hospital that we know and we respect and do business with. Yeah. Yes, we are working on that. We're also working on putting some standardized language in the for those that use kind of standard dictation on the informed consent discussion, there should be some standardized language in that as well in terms of, you know, it was discussed with the parents that trainees will be involved and they will perform these parts of the procedure and I will perform these parts, you know, so that we're making it as clear as we can who exactly is doing what. Yep. Right. No, because the attending is ultimately responsible. So the question for those on the WebEx is, if the resident's getting consent, then does that give us cover? And the answer to that is the attending is always going to be responsible for that because, again, the resident doesn't have a license to practice independently. We're responsible for supervising them. And so there needs to be good communication between the attending and the residents in terms of expectations about what's being covered.
Question, Becky, I'm sure other things when I send in surgery, should I say, I do not, that I have residents in my person as well? Are you suggesting that this is going to go in the hot tub?
I am suggesting that's a good idea. Yeah. 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 Yep. That level of detail, I don't know. I'm sure the attending was.
That's all the difference in this case.
Yeah.
Because if the attending wasn't really there supervising, then the approach is different
right.
than making dramatic changes in the consent process, in my opinion.
The information that I have on the case didn't indicate that level of detail as to whether, I mean, I think clearly if the attending's not even in the room, that's a big problem. I don't know the answer. It wasn't part of the published opinion. Yeah. Hang on one sec, they're bringing you a mic.
When patients and their families come to the hospital for care, they do have to sign a consent to allow us to take care of them. Is it in the consent in the beginning, in the agreement that there'll be residents and trainees taking care of them from the beginning?
I'm sorry. Can you ask me again?
Yeah, sure. So the question is, there needs to be an understanding, obviously, from the patient's and the family's point of view that when they come to an academic center, that trainees will be taking care of them, correct?
Yeah, I mean,
and so if I brought my child to this hospital, would I have to sign something saying I understand that trainees will be taking care of my child?
There is language to that effect in the general consent to treatment.
So, I mean, so doesn't that cover us for whatever treatment they get?
You would think.
Okay.
Yeah.
But again, we don't know enough about this
right.
case to extrapolate to our circumstance. I would argue, because we don't know if they had that in their general consent as we do. We don't know that the attending physician was providing proper supervision, and that's what persuaded the jury. So I'm just a little hesitant to have a big sea change in our practice based on what we don't know about this one case.
This issue had not gone, this was a question that the judge had to determine. So they were trying to get this claim thrown out as a matter of law and motion. So in other words, this shouldn't even go to the jury because they haven't stated a claim legally, and the judge disagreed. They said, no, I think this needs to go to the jury, okay? What that means is that based on the facts of the situation, you may end up having to go to a jury on this case. The judge isn't going to throw it out, okay? So that the procedural aspect of the case is important. Normally you would be able to get this out on a motion to say to the judge, they shouldn't even be able to take this claim to the jury because they haven't stated a case under what the law requires, and the judge said not so fast. I think there are enough facts to get this to the jury. Okay? Yeah, I'll see if I can get those details. There's another question.
Sorry. My name is Amanda. I'm a third-year pediatric resident. I had a question. You mentioned that it was a big problem that the attending was not in the surgical suite during the procedure. I had a question about, like, a kind of twofold question. The first is, my understanding from my friends who entered OB-GYN is that in that area, it's pretty common for a senior resident in their last year to be the, essentially attending or head surgeon on a case, and then the junior resident to be assisting, with an attending frequently not in the room, but available if needed. And so I was kind of just wondering how the results of a case like this could change residency practices for surgeons throughout different fields. And then the other question is from a medical point of view, for medical residents like us, does it mean that an attending has to supervise how much or what percentage of our patient interactions and our decisions therefore have to be supervised by an attending? And at what point are you allowed to have some autonomy?
So I think these issues are really focused on the proceduralist, and that's a fantastic question. These legal issues focus on proceduralists. And I can't really comment on what other organizations do, and especially in terms of OB kind of stuff, it's not what we do here. But I think the concept is the same. If you're delivering a baby, that's a procedure. If there's some kind of complications and you have to do, a C-section, or you have to do something, use forceps, use a vacuum, then those are procedures, which are requiring, there's an informed consent component there. And so, I would, if this were a hospital that did deliveries, I would be concerned about that practice. So, yeah. An LP.
So in a way, that it plays out in our own hospital, where there's sort of differences of expected attendance participation in these things.
Yeah. So we need to look at it. We shouldn't overreact, but it's just, the reason I bring it up is because, again, it's so close to home. I just want to create situational awareness around the fact that this is a risk. And again, the cases are all dependent on the facts. But the point to drive home here is for procedures in the OR that require, or procedures that require informed consent, we just want to take some reasonable measures to protect ourselves from someone saying, hey, I didn't know that a trainee was going to be involved in this. Okay. Great discussion. Okay. Question number 2. We have a 13-year-old patient with a complex spinal deformity who's going to have corrective surgery. The surgeon doing the case has only done this kind of surgery once as a fellow, but the co-surgeon has done it several times. So the question is, does the surgeon need to tell the parents about his level of experience with this procedure? Same questions as before. So A for yes, B for no, C for not sure. I'm thinking it might not be working. All right, anybody want to say why they think it might be yes? Anybody? Anybody? Right. Right.
What is a really simple file? Does you train to do surgery? I'm going to speak with
Not working.
Anyway, if you're trained to do surgery, you have to simple file. You have to tell them, oh, by the way, I'm trained, but I haven't done this one. Live in this case. Oh, it's a patient. So then you give it to the customer. You have a.
But there's someone who's, as you say, is an experienced co-surgeon who's done it a million times. So the team, our team is fantastic. We've got the best team in the world.
I'm gonna. Lisa's gonna be my candy giver.
I just wanted candy, by the way.
I don't want to take this back upstairs. You get some. So this was an actual case. One of our cases actually, and this was a complex surgery. The patient lost neuromonitoring signals during the case, ended up paralyzed from the waist down. We got sued, okay? The experts that the patient's attorney hired in this case gave opinions under oath during their deposition that the surgeon was in fact required to discuss his experience with this procedure with the parent. He claimed that he did so. The mother, of course, claimed that she didn't hear that. And of course, you know, after the fact, we know there's a bad outcome, so, you know, it's human nature. It's easy to go back and say, no, if I had known, I wouldn't have let him do it, right? But the co-surgeon had done it several times, and, you know, this complication developed during what was considered to be the least risky part of the procedure. So again, complex case, I'm just using this to illustrate a point that from the parent's point of view, as Dr. Packer elicited, this may be really important to a parent. Here's the other tricky thing here. So sometimes we do procedures for kids that are risky, and they're really risky, right? But the kid really doesn't have very many other options. So the tension here is that we want the parent to understand the risk, but we don't want to scare them half to death, right, to where they'll be like, no, I can't possibly do this. You know, there's a cardiac surgeon out in LA, Wynn Wells, who used to tell his trainees, if the mom's not crying by the time you're done with the informed consent discussion, she doesn't understand. And on the one hand, you go, yeah, there might be something to that. But on the other hand, if the goal is to get the child the treatment that we really believe is in their best interest, then it's a balancing act. So no big surprise, these are difficult conversations, which is why, and I'm going to give the mic to Lisa and Mary for a moment. They're going to talk about some important simulation work that we're going to be starting with folks. we have identified through looking at our legal cases that we end up, getting sued for procedural cases more than really anything else. And a large component of those cases has to do with informed consent. So I'm going to turn this briefly over to you guys to talk about the simulation work that we're going to be launching.
Becky, can I just make a quick comment to this?
Yeah.
So they're not getting sued because of their style of informed consent. They're getting sued because of the complication of the surgery.
Yes.
You can say whatever you want. If you have a great result, no one's going to sue you.
Bingo. That's exactly right. Yeah. There wouldn't be a case here unless there had been a complication. That's absolutely true.
And actually what we want to say inside of that is, a big part of what we've seen, we even have a transcript from a conversation, post something happening is, and this is going to have everything to do with the work we're going to do, is how we have those conversations back with the families and what their perceptions is. Does it sound like a disclosure or does it sound like what it's supposed to be, which is it is a known complication? And we're doing a lot of data analysis now. We're looking. So even in real time, some kind of a notice comes in from an attorney, whether it's that they're just starting to look at medical records or they've actually filed a case, and we see these known complications. We see, particularly procedurally, where we put in some kind of a catheter and the patient had a stroke or it went in the wrong vessel, whatever it might be. So, really there's going to be some opportunity around how we do sit down and address the issues with the family.
Yeah, so just very briefly, as Becky said, we are embarking on some work that will ultimately probably involve everybody, but it's related to both disclosure of what could be a known complication or perhaps a more negative event, as well as around informed consent. And those buckets of work will include opportunity for everybody to have some additional level of knowledge, probably as well as focused training for individuals who are potentially in high-risk areas, as well as who are always around when the bad things happen, so basically in the middle of the night when we all know that that's when most bad things come to light, as well as then more focused training for individuals and specialties that are at high risk in terms of the procedures they perform, as well as basically that they have the riskier procedures and the higher risk patients. So this is coming down the pike in the next calendar year or so. We expect that some of this work will be being rolled out in the beginning of the new calendar year. So just to know that it's on your radar.
So top 10 elements of informed consent. We usually abbreviate this by saying, risk, benefits, and alternatives. Those are the top three. There's a little more nuance to it. What are the risks of doing something else other than having a procedure? The risk the procedure won't work, any need for additional surgery, specific risks to the procedure, the general risks in terms of anesthesia, infection, bleeding, death, those kinds of things. What's the recovery process going to look like? For example, if an adult's getting a hip replacement, the recovery piece of that is a significant thing that they're going to want to know about. Lead surgeon assistants, their roles, experience with the procedure, and then typically questions and repeat back should be part of that process. And again, while the forms are very important, and we need to make sure as an organization that we're getting the forms signed, that they're signed by the right people and so forth, and that they ultimately get into the chart. We shouldn't focus on the form versus the process. A signature on a form is simply a validation that the process and the conversation has taken place, okay? But it's not a substitute for that conversation. Yeah.
Cardiac is that they also want to know what are the provider's specific outcomes, short and long term.
Interesting.
In other words, they don't want to know, well, the national average for this procedure is a 2% mortality. They want to know what either that institution's or what that provider's specific outcomes are. And they're moving towards even longer term, because most of it, like for cardiac, we know 30 days. We don't know 1 year, 2 year, 5 year, and we speculate on that, but that's being asked.
That wouldn't surprise me in the least. And we know that, you know, parents have access to the internet, almost everybody does, but there's really too much information out there. Folks start to read and they can get more, you know, it can be less helpful versus more helpful, but savvy consumers will ask you those questions, and so I think we should be prepared to answer them. I know, I would suspect some of that data is, I don't know if it's necessarily public. Do we put it on our, does the government report it, or do we put it on our website?
For cardiac, there is a Society of Thoracic Surgery that has a public reporting of it. It's not particularly robust at this point. It doesn't provide a lot of detail. Many things are lumped together. So,
yeah, it doesn't surprise me at all. Yeah.
You know, Becky, when I look at this list of the top 10 elements here, it's a bit overwhelming to think about going through all of those and giving them all the important due that they each deserve. Which leads me to the question about, which I think is in the literature a lot, about the videotaping informed consent. And the way I've read it is it really cuts both ways. It documents that you actually said something, but there's also a literature that says it improves what the consentor does, because she or he is more likely to go down this list of things if they know that they're being videotaped.
So that's interesting that you mentioned that, because I'm actually working with a couple of physicians, Dr. Pohl and Dr. Sigmund, on looking at platforms, vendor platforms for an informed consent process for our highest risk procedures. And what I mean by that is the procedures that are complex and that have risks of material, really significant complications, like the ones that we get sued for. Of applying a special informed consent process to those high-risk procedures, which could involve there's a pretty cool online platform where the family goes to this website, they view a teaching module, they have to answer questions on that module, and if they answer them wrong, they get, no, that's wrong, here's the right answer kind of thing. There's, it's all documented, so you could go back as an evidentiary matter if you needed to and say, well, look, the parent listened to this thing, they answered all the questions right, this particular issue was covered there, and then, by the way, we have a videotape of the informed consent discussion. It's something that's available. We're talking about it. I certainly wouldn't advocate it for everything we do. It's kind of like, killing a fly with a hammer, but for some, and the surgeons are going to have to figure out what those cases are. It's not, my purview to do that, to where maybe there's a place for this kind of specialized process or an informed consent for certain kind of things we do, and that's done. And some places do it for all kinds of procedures. I think that's kind of like killing flies with hammers, but it's something we're thinking about. So more to come on that. Thanks. All right, there are exceptions. Obviously, we deal with emergencies, and sometimes we have to provide treatment to prevent serious injury to the patient, and we can't find the appropriate consenting party, or if the patient's an adult, they're, because of their condition, unable to tell us, yes, go ahead and do this, save my life. So in that instance, 2 surgeons or 2 physicians can sign. But we should make a real effort to reach the parents, and we should enlist social work to try to help us with that. But again, if the patient's going to die or suffer material harm if we don't proceed, we should go ahead under the emergency exception. And, there are a lot of questions around informed consent, and they're not always easy, and they're not always, clear answers. So I just want to make sure everybody's aware that RISC has literally a dedicated person every single day of the week to answer your consent questions. So if something comes up and you're not sure what to do, please call, and we will get you to somebody who can help you answer your questions. All right. Question number 3. So we have a developmentally disabled 25-year-old patient who undergoes abdominal surgery after consent is obtained from her mother. She develops complications and eventually dies. The mom sues for malpractice and assault and battery on behalf of this, her deceased daughter. Do we think she has a good case? Let's vote yes. A for yes, B for no, C for not sure. Now it's working again. That's weird. Okay. All right, most of you think she does not have a good case. So this was an actual case from several years ago, but the mom's claim for battery was allowed by the judge to proceed. This would have gone to a jury if we hadn't resolved it. Here's why. When a patient becomes an adult, then they're an adult, and their parent can't just sign for them. And so steps need to be taken in order for it to be legally appropriate for that parent to make medical decisions for that adult patient, okay? That can get tricky depending on the jurisdiction. In D.C., they have a law which allows us to let that parent sign, but we have to have 2 physicians certify that the patient's incompetent. There's a document we have for that purpose. And then once the 2 physicians certify the incompetence of the patient, then the law, but kind of by operation of law, then the parent would be allowed to sign on their behalf, and it would be legal, and they would be, you know, the appropriate person to do that. So we've done a lot of work. Laura Tosi with the Older Patient Committee has led some work educating families about the fact that, you know, yes, this is always going to be your baby, right, no matter how old they are, but once they turn 18, in the District of Columbia, they have the legal right to control the information about their health care and make all their health care decisions, unless they're incapable because of their disability of understanding and making those decisions. So it's just something that we need to have people be aware of. If the patient's over 18 and they're not mentally competent, we need to be asking questions about, okay, who's going to be consenting for this patient and what kind of paperwork do we have in place to make that okay? Because technically, if you do a procedure to a patient without their informed consent, under the law, you have committed assault and battery. Okay? Yeah. Right. Right.
If the family has that,
yeah,
then that family is allowed
yeah.
to make that.
Right. Either we have to do the 2 physician certification, or the family has to have some kind of paperwork from a court saying, hey, I'm the judge, I'm appointing you the guardian of this person. We run into problems with families in Maryland on this because under Maryland's law, the parents don't have to go get guardianship. So Maryland says it's okay if you're a parent of a disabled person and they become an adult. We, the state of Maryland, don't think you have to go to court to have a judge determine if you're an appropriate guardian for this person. As all you have to do is file this paper with Maryland saying, I'm their parent, I'm going to take care of them, and Maryland says, yeah, that's cool, that's fine. That may be fine for care in Maryland. It's not fine for care in D.C. So we see this issue arise most often with parents from Maryland because their state doesn't require them to do that for all those benefits issues. People in other states, you know, will have those issues if they're not guardians. And the issue with a lot of these families is they don't have the money or they just don't know how to go make that process start happening. And we can help the social workers and folks get them to places that will help them if it's necessary. But for kind of a stopgap, we can do that to physician certification. The other thing is, you know, disabilities are on a spectrum. Not every disabled adult is completely incapable of making any decision, right? So we need to let them make the decisions that they're comfortable and that they're capable of making.
For example, you may have a disabled adult patient that's perfectly capable to decide, yeah, I want to get a flu shot. Yeah, I'm okay with this IV if I need something under sedation, but they couldn't consent to complex, cardiac, spinal, or brain surgery. And so in those cases, you let the patient do what the patient's capable of, and you have and facilitate them signing a power of attorney so that their parent can make the decisions for them that they and the team agree or not within their ability. So that, and then we have a document for that as well. Social work is pretty aware of these options, but if you need help with those, you can always call us on that. Okay. All right. So we've kind of already dived into this. Parent or legal guardian, some other adult with written authorization from the parent or legal guardian, competent patient who's 18 years or older, emancipated minor. The emancipated minor thing confuses folks a lot. That's a legal term. A patient really isn't an emancipated minor unless a judge says so and gives them paperwork to that effect, so be careful there. But there are circumstances under which a minor can consent to their own care that don't require them to be emancipated. And it's usually kind of what I call this sex, drugs, rock and roll. They can consent for sexually transmitted diseases or sexual assault. They can consent for outpatient mental health treatment. They can consent for substance abuse treatment. Okay, but that depends on the state. So if you're seeing somebody in Maryland or Virginia and you're not sure, give us a call. We have a chart that we can walk you through. Yep. Yep.
Because my understanding is that if they're receiving treatment here, what applies is what goes on in D.C.
Right.
Regardless of where they live.
The law that we care about is the law in the location where the care is actually being provided. Okay. So these are kind of the legal constructs under which minors are allowed to consent. And again, it depends on the jurisdiction, but these are just kind of things to keep in mind. Obviously, we include minors in the research process where it's developmentally appropriate, but it's really an assent, most of the time versus a consent. All right, so special circumstances, we get a lot of questions. This is probably 99% of the questions we get are these special circumstances. Divorced parents, the bullet on that is unless a court says otherwise, either parent can consent to anything. The only thing we really need both parents to agree on would be if we were doing research on that kid that was more than minimal risk with no direct benefit, and that's the only circumstance I can think of where we absolutely have to have both parents. So, but the divorce order may say parents have legal custody, but if they disagree on medical issues, mom gets to make those decisions. So if the mom and dad are not agreeing and mom says, hey, I have the right, I get tie-breaking both here, then we need to see the paperwork that indicates that. And again, send it to us. We'll look at it and confirm for you what exactly the deal is. But otherwise, we really don't. We could get consent from either parent. We talked about the incompetent patient who's over 18. Foster parent, usually foster parents don't have the right to consent. Usually the parent still retains the right or the state has the right. And so those are, every circumstance is different and we need to get those specifics. Sometimes if the patient is in foster care, then the county social worker is the one who ends up having, or the delegatee of the director of social services for that jurisdiction. And then we have patients over 18 who want their parents to remain involved. That's great. We should facilitate that. But then the family just needs to understand we have to do that with the patient's permission. If the parents want the records, the patient has to sign a release saying we can share information with them. And they just need to understand that while the parents are an important support for the patient, at the end of the day, the patient must sign the consent form. Okay? They can't really, if they're competent, it's not appropriate for them to be ceding that responsibility to their parents. Yeah.
We have had circumstances where the charges award and it's not the decision of approving a treatment, but of withdrawing treatment, like life support and so on. And it's been very difficult. Has there any changes in that area?
Well, if the patient's a ward of the state's usually going to want to go get a court order allowing them to allow us to withdraw care. I know we've had a case, gosh, within the last 12 months on that, I'm pretty sure, that where we were heavily involved in talking with the folks in Virginia about sort of making that happen. You know, state actors are not typically when a judge gives, you know, the state the right to make these decisions, they don't necessarily want them making withdrawal of treatment decisions without a judge also being involved in that. So that's not unusual, and I wouldn't expect that to change. All right, so I think this is our last question. You're the surgeon about to perform a routine procedure on a child patient. You come to the pre-op area to meet with the parent and obtain the informed consent. Now, this is obviously assuming that hasn't happened yet. The parent's slurring speech has dilated pupils and is having a hard time staying awake. And you have the parent sign the consent form. A for yes, B for no, C for not sure. All right, so the majority of you say no, and I would say that that's the right answer from where I stand. You want to, not only should the parent be the appropriate person legally, but we need to make sure that the parent's capable of understanding the risk, benefits, and alternatives. So if the parent's either having some kind of a medical issue here or perhaps is under the influence of something, that would not be valid consent. So what do? Well, let's see if there's another, where's the father? Is there somebody else who can give consent on behalf of this child? Is there a grandmother or somebody there that we can say to mom, hey, is it okay if grandma consents to this? And then we have the discussion with grandma. If there's a father, then we get the dad. But if there's nobody else, if mom's the only one there, then we have a couple of issues. Number one, the consent wouldn't be valid, arguably. And then, you know, how do we make sure these folks get home safe? Because you don't want to put a kid in a car with an impaired person for them to drive home and potentially have an accident. So this is a case to get social work involved and to call us for advice. But the advice here would be don't have her sign. See if we can get somebody else to sign. If we can't, and it's not an emergency, we may need to postpone the case. And then have social work on, you know, how do we make sure that this doesn't happen next time, okay? Well, that's a little bit of a stretch. You know, if mom's really that messed up, then she probably can't legally authorize somebody else to sign for her. But it may be a situation where grandma's been bringing the kid in all along and mom just happens to show up for the surgery. So if we have an authorization to consent, if we have something already in writing where grandma's been involved, then we could use that to let grandma sign. But you're right, if mom's messed up, we probably don't want to take her delegation to grandma at that moment. But there may be something in the chart that allows us to do that. Yes. Sorry, there's somebody right behind you, Tony. Go. Yeah.
Thanks. So how would you handle it when the parents have developmental delays also?
Well, if the parent has developmental delays, then it's kind of the same assessment as though it were an adult patient who is delayed. Is the parent capable of understanding the risk, benefits, and alternatives of the proposed treatment and making an informed decision? If the answer to that is no, somebody else has to make the decision for this kid. And that's a process that hopefully we identify very early, you know, and not when the kid's in the pre-op area. So the options are kind of the same as with the adult incompetent patient. You know, if the disabled parent has the capability to delegate, then we ask them to delegate in writing to somebody else. If they don't, then we need to get the government involved where the child and family live to appoint somebody to be that kid's decision maker. The other thing is minor parents. So if you have somebody who's a minor and they're the parent of the child, as long as they're developmentally capable of understanding, they can sign. Okay? Yeah.
Becky, this becomes a gray area because where is the cutoff? So let's not say they're impaired, but just let's say they're simple and they have no understanding of medical issues. So you're going to do an inguinal hernia and you tell the mom, you know, that we could cut the duct or the blood vessel that goes through the testis and that carries the sperm, and then it happens and you cut the duct, and then the mom says, I had no idea that my child wouldn't be fertile after that. I would never have allowed the surgery. Where is the cutoff in the whole process? I mean, what's reasonable, what's unreasonable for understanding?
Yeah, so I think there is a lot of gray here, and at the end of the day, it's have we communicated to the parent in a way that they're able to understand and say back to us what they've understood us to say. So it may be a situation where more than one teaching opportunity needs to happen before that consent is, you know, complete. It may be that the parent needs someone to kind of help them translate. You know, we do that a lot with disabled adults where there's something that a disabled adult may be able to do and their parent can kind of help them understand because the parent knows how to communicate with them in a way. But we just need to focus on trying to be as simple as we can when we're describing things. If we believe that the parent is not sophisticated or doesn't necessarily understand a lot of medicine, I mean, there are ways that we can explain things to them that they can understand. But the point is that we need to validate that information has been received, and the best way to do that is by having them repeat back to us in their own words what they think we're going to do and what the potential problems might be.
And you're absolutely right, and this is critical work, and we have to do the best we can do. But my point really is there's nothing foolproof about whatever we do. We could spend 2 hours with each patient, and there'll still be a loophole that they can get us on.
It's true. This is about doing what's reasonable to try to make ourselves less vulnerable to these claims. Because as you rightly point out, we wouldn't be having this discussion if nobody ever had a surgical complication, right? Yeah.
Non-English speaking, for non-English speaking patients. We have a consent form in Spanish, and we have a consent form in English, and I think there's one in Arabic. Is the expectation that I can't read Spanish or Arabic, do I just sign the English form and the patient signs the language that they understand? Or is there an expectation, because you don't have a bilingual form like where you have English and Spanish, or English, you know, like, which would be nice because then one person, everybody could sign the one form. I can't sign the Spanish form because I don't understand what's written on the form.
Well, the Spanish form is a literal translation of what's on our English form. To me, it seems like the signatures should all be on the same form. We often are asked, well, do we staple a copy of the English version with that? Because it seems like language services is probably writing in the procedure in the language, right? So we're not going to have a Spanish form with the name of the procedure written in English, right?
So, so what happens is I end up writing it in English.
Okay.
Because oftentimes I'm using the Marty.
Okay.
You know, the computer.
Okay.
And there's nobody to write it in.
Okay. Let me give that some thought.
Because, the other thing you could do is just develop a form that has both languages on it. It's a little bit longer, but, I mean, it's either 2 forms or, or one longer form.
Right. Documents can be executed in parts, so to speak. So theoretically, you could have someone, the surgeon signing the English version, the patient signing the version in their own language. It's a little bit tricky though when we're writing in English on a Spanish form or an Arabic form. Let me give some thought as to how we can tighten that up because I think that's a vulnerability.
Becky, that was your initial recommendation for revised consent, but then we thought of Tony trying to write something in Spanish, and we basically said that's not going to work. So we came back, and I don't see a way around that.
That's tricky. I think I'm going to need to, I want to give that some more thought because this is an important question. So I will get back to you on that. But and I do think we're making moves towards doing a completely electronic consent form, which may kind of help iron out some of these tricky operational issues. But I think it's a good question. I don't think there's necessarily a dead right or dead wrong answer to it. I think doing what's reasonable in the meanwhile is a good practice. And I don't think the fact that we would be signing two forms is necessarily a bad thing, but let's look at how to make that tighter for everybody.
It would certainly seem, by everything you've said so far, that we're going to have to send a package to parents, at least for elective procedures, well ahead of time with a lot of material on it, that somehow we indicate that they've read it or acknowledge it or something like that, because what you're asking for cannot be done in a pre-op setting or whatever.
Yeah. I think the major problem that we have is our consent forms are so long and so complicated that they are a way for me to hide behind the consent process. And I think you just got to be realistic and tell them what really might happen and be very honest with them. And if you want a laundry list of 750 complications, because somebody at some IRB said you needed to have 750, that's fine. But I think it's crazy to go one by one. If the consent is being used as a way not to interact with the patients, and you lit me up, we said, now we're going to do it electronically. I think you got to spend time and be very honest in what the logical things that might happen, what your experience is, and I think that's your best cover, not hiding behind a consent form that's now 15 pages.
Right. And that's a good point. You know, you're not required to disclose every single possible complication, just the ones that are likely. And that's all based on not only your own experience, but what the literature shows us. So a couple of these last slides are from, I understand we're over time, so I'll go through these quickly. These are lifted straight from our medical staff policies and procedures and our informed consent procedure. So the procedure list retains the responsibility to get informed consent. This slide indicates who those are. So whoever's doing the procedure, the diagnostic or invasive procedure or treatment, anesthesia or sedation. This is what our policy says about the trainee role in that process. So the procedure has to co-sign and date the consent, verifying that it's correct, but the resident or fellow may have the discussion with the parent and patient prior to or on the day of surgery. This has to do with practitioners other than physicians and specifically related to blood or blood products or other procedures done by members of certain divisions. So this is lifted straight from the policy. I won't spend a whole lot of time on it unless there are questions. I want to get to this. English as a second language. Beware of using a non-certified interpreter, i.e. a nurse or a surgeon, or asking the child patients themselves to translate. Under federal law, those don't qualify as what we are required to do. Okay, so we need certified medical translators, and if you're having difficulty obtaining those services, whether there's a backup or there's delay or whatever, please escalate those or send in an RL because we need to track those, and also be aware that there has been a recent kind of a spike in complaints by hearing impaired parents about the sign language translation services. There have been a couple of big governmental actions against hospitals in the South related to their failure to provide appropriate ESL services. So just something to keep on your radar. And please, again, do let us know if you're having trouble getting those services in a timely fashion for your families. Objection to treatment on religious grounds. The bullet point here is a child really cannot be subjected to something that might harm them or have care withheld from them on the basis of the parent's religious beliefs. So if you find yourself in that situation, please do call us right away. The most common thing has to do with blood or blood transfusion. We have language on this this is our policy for informed consent as to what should happen. There's language on the blood consent form that basically says, you know, parent, if you object, you can sign this just acknowledging that we're going to do this over your objection. And obviously we take any medical steps that we could to avoid blood administration, but at the end of the day, if the kid really needs it and harm's going to come, we can do it over the objection of the parents if we need to. Phone consent. The one thing I wanted to highlight here is that we really have to have that witnessed by another healthcare professional, and both of them need to document the discussion in the medical record. We had an event happen recently where there was a phone consent obtained for a procedure, and this documentation part wasn't done, and the parents came back later and said, we never consented to this procedure. So it's really important that this documentation takes place. Because we do phone consent, it's okay, it's legal, it's appropriate, but we just have to document it. Okay? All right. Thanks so much. The questions were so good, I should have had less slides, but this is how you can contact us. You don't need anyone's permission to call and ask for help. And there's somebody available 24/7, 365. Yeah, thank you.
One last question. If you're consenting parents, which one speaks English and one doesn't, they're discussing it together, does that make an informed consent or not yet?
If I were doing consent with parents where one was an English speaker and the other one wasn't, I would have a translator for that parent who is not an English speaker.
But the English-speaking parent can sign the English form?
Yes,
that would be,
yes, the English-speaking parent can sign, yep.
Thank you.
Thanks, everybody.